This case considered the issue of omitted easements, and whether or not the existence of an implied easement created personal equity rights against a servient tenement, where both the servient and dominant tenements were created out of a transfer from the common owner of both tenements. In this case, two properties owned by one owner were situated next to a third property. There was an easement that existed that burdened the two properties that gave a right-of-way to the third property. However, this right-of-way had not been registered on the titles. The owner of the two properties decided to sell these properties. She sold one of the properties to the owner of the adjoining property that was using the right-of-way and the other property to a third party. Draft conditions were prepared in relation to the right-of-way, but were not included in either of these contracts. The party that was using the right-of-way had been incorrectly advised by their solicitor that this was not necessary, and so continued to use the right-of-way until a dispute arose 25 years later between these two parties regarding access over the right-of-way. The owner of the property, which had the driveway across it, argued that there was no easement that could be recognised by the Real Property Act. However, the party that had been using the right-of-way argued that the circumstances of the sale of the properties gave rise to an implied easement, on the basis that the owners of the land knew of the existence of the driveway and that they had an intention that they were taking the land subject to it. The central issue for the court, therefore, was whether or not the circumstances that arose out of the transfer of the properties gave rise to the creating of an easement in relation to the right-of-way, and if it could be implied into the contract for the sale of that land that they acquired the land subject to that right-of-way. The court ultimately held that the alleged implied